morning, Attorney Aquino and classmates. I am Jose Gianmarco Navarro of Group 5, and we will be reporting today. The contents of our report will be 5 cases on vacancies, 2 cases on local legislation, 2 cases in disciplinary power, 3 cases on recall, and 1 case on election laws. So let's go to the first case, Gamboa versus Aguirre Jr. So in 1995 elections, Coscoluela, Gamboa, Aguirre, and Araneta were elected as Negros Occidental Governor, Vice Governor, and Sangguniang Panlalawigan or SP members respectively. Sometime in August of 1995, the governor designated Gamboa as the acting governor for the duration of the former's official trip abroad until his return. When the SP held its regular session on September 6, 1995, the respondents questioned the authority of Petitioner Gamboa to preside therein in view of his designation as the acting governor, and asked him to vacate the chair. The latter, however, refused to do so. Thus, on September 22, 1995, the respondents filed before the lower court a petition for declaratory relief and prohibition, and during the pendency of this case, Coscoluela reassumed his office as the governor. The trial court rendered a decision and declared the petitioner as temporarily legally incapacitated to preside over the sessions of the SP during the period that he is the acting governor. So the issue in this case is whether or not an incumbent vice governor, while concurrently the acting governor, may continue to preside over the sessions of the Sangguniang Panlalawigan. And the answer here is no, because Section 49A and 466A of RA number 7160, or otherwise known as the Local Government Code, provides that the vice governor shall be the presiding officer of the SP. In addition to such function, he becomes the governor and assumes the higher office for the unexpired term of his predecessor in case there is a permanent vacancy of the governor. However, if the vacancy of the governor office is only temporary, the vice governor only automatically exercises the powers and duties of the governor. So, when the vice governor exercises the powers and duties of the office of the governor, he does not assume the latter's office. He only acts as the governor, but does not become the governor. His assumption of powers, duties, and functions of the provincial chief executive does not create a permanent vacuum or vacancy in his position as the vice governor. Necessarily, he does not relinquish nor abandon his position and title as vice governor by merely becoming an acting governor, or by merely exercising the powers and duties of the higher officer. So, does the vice governor relinquish his powers as the vice governor when he is the acting governor? And the answer is yes. A vice governor who is concurrently an acting governor is actually a quasi governor. This means that for the purposes of exercising his legislative prerogatives and powers, he is deemed as a non member of the SP for the time being. So the conclusion here is, being the acting governor, the vice governor cannot continue to simultaneously exercise the duties of the latter office. Since the nature of the duties of the provincial governor call for a full-time occupant to discharge them, such is not only consistent with, but also appears to be the clear rationale of the new code, wherein the policy of performing dual functions in both offices has already been abandoned. To repeat, the creation of a temporary vacancy in the office of the governor creates a corresponding temporary vacancy in the office of the vice governor whenever the latter acts as governor by virtue of such temporary vacancy. Wherefore, the petition is denied for lack of merit. Navarro versus Court of Appeals et al. So facts of the case are as follows. In the 1997 local elections, Cesar Calimlim and Baltazar Aquino were elected mayor and vice mayor of the municipality of Mapandan, Pangasinan, respectively. In the same election, Danny Tamayo was elected as member to the Sangguniang Bayan, garnering the most number of votes. On March 25, 1999, Mayor Cesar Kalimlim died. Thus, a vacancy was created in the office of the mayor, and by operation of law, under the local government code, then Vice Mayor Baltazar Aquino succeeded him. Accordingly, the highest member of the Sangguniang Bayan, Danny Tamayo, was elevated to the position of Vice Mayor. Since a vacancy occurred in the Sangguniang Bayan by the elevation of Tamayo to the office of Vice Mayor, Governor Victor Agbayani of Pangasinan appointed herein petitioner Porto Navarro as member of the Sangguniang Bayan. Navarro belonged to the same political party as that of the petitioner Tamayo, that being Reforma LM. The private respondents thus filed a civil case to nullify the appointment of Navarro, and the RTC denied the petition. On appeal with the Court of Appeals, the respondents argued that it was the former vice mayor succeeding to the position of the mayor who created the permanent vacancy in the Sangguniang Bayan, because under law, he was also a member of the Sangguniang. Thus, the appointee must come from said former vice mayor's political party, in this case, Lakas Kampi. The CA ruled that it was the appointment of the eighth councilor, who was Rolando Lalas, to the number 7 position, which created the last vacancy. Therefore, the person to be appointed to the vacant position should come from the same political party to which Rolando Lalas belonged, which is Lakas NUCD Campi. So the issue here is whether or not the appointment of Navarro is valid. And the answer is yes. Under Section 44 of the Local Government Code, a permanent vacancy arises when an elective official fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office, voluntarily resigns, or is otherwise permanently incapacitated to discharge the functions of his office. What is crucial is the interpretation of Section 45B, providing that only the nominee of the political party under which the Sangguniang member concerned has been elected, and whose elevation to the position next higher in rank created the last vacancy in the Sangguniang, shall be appointed in the manner herein above provided. The appointee shall come from the political party as that of the Sangguniang member who caused the vacancy. The reason behind the right given to a political party to nominate a replacement in a permanent vacancy is to maintain the party representation as willed by the people in the election. So with the elevation of petitioner Tamayo, who belonged to Reforma LM, to the position of vice mayor, a vacancy occurred in the Sangguniang that should be filled up with someone who should belong to the political party of Tamayo. Otherwise, Reforma LM's representation in the Sangguniang would be diminished. To argue that the vacancy created was that formerly held by Rolando Lalas or under the Lakas Campi member will result in the increase of that party's representation in the Sangguniang at the expense of Reforma LM. This interpretation is contrary to the letter and spirit of the law and thus violative of a fundamental rule in statutory construction, which is to ascertain and give effect to the intent and purpose of the law. As earlier pointed out, the reason behind paragraph B of section 44 of the Local Government Code is the maintenance of party representation in the Sangguniang in accordance with the will of the electorate. Wherefore the petition is granted and the appointment of Porto Navarro to the Sangguniang Bayan is affirmed. So before we end, I made here an illustration to illustrate what happened. So in this table in the left, this was the original lineup of the election. So Cesar Kalimlim was elected as mayor, and Baltazar Aquino as vice mayor, and Danny Tamayo is the member of the Sangguniang Bayan who garnered the highest votes. Now, Cesar Kalimlim passed away during his term. Thus, in the table on the right, Vice Mayor Baltazar Aquino assumed the position of mayor, and Danny Tamayo was elevated to vice mayor since he was the highest the member of the Sangguniang Bayan with the highest votes. Now, because Tamayo was from the Reforma LM, when he elevated to vice mayor, there became um, a vacancy in representation from the political party of Reforma LM. Thus, the appointee for the vacant slot left by Tamayo should also be a member of this political party, Reforma LM, which in this case was Purto Navarro. Morales versus Comelec. The facts of the case are as follows. Marino Morales was elected and served as mayor of the municipality of Mabalacat, Pampanga from July 1, 2007 to June 30, 2010. He was elected again as a mayor during the 2010 elections. On May 15, 2012, or during Morales' second term, Congress passed RA 10164 converting the municipality of Mabalacat into a component city. Thereafter, a plebiscite was held. In the 2013 elections, Morales ran again and was elected as mayor of the new Mabalacat city. On December 8, 2015, Morales once again filed his certificate of candidacy for the 2016 election for the same position of mayor of Mabalacat City as a substitute candidate for Juan Wilfredo Feliciano of Acción Democrático Party. On January 4, 2016, respondent Pyra Lucas, also a candidate for the position of mayor of Mabalacat City, filed a petition for cancellation of the COC of Morales for the mayoral position, contending that Morales was disqualified to run for mayor since he was elected and had already served 3 consecutive terms prior to the 2016 elections. On May 10, 2016, following the canvass of all election returns, the City Board of Canvassers of Mabalacat City proclaimed Morales as the elected city mayor and petitioner Christian Halili as the elected vice mayor. On August 3, 2016, however, the Comelec First Division granted the petition and cancelled Morales' COC and ordered the proclamation of the qualified mayor candidate with the next higher number of votes, this being Crisostomo Garbo. The Comelec and Bank affirmed the First Division's ruling. So the issue of the case is as follows. Whether or not the Comelec committed grave abuse of discretion when it proclaimed Garbo as the duly elected mayor of Mabalacat City. And the answer is no. So the first item to tackle is the term limits of local officials. So Article 10, Section 8 of the 1987 Constitution provides that the term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. There are 2 conditions which must concur for the application of the disqualification of a candidate based on a violation of the 3-term limit rule, and that is 1. The official concerned has been elected for 3 consecutive terms in the same local government post, and 2. That he has fully served the 3 consecutive terms. So in this case, Morales actually admits that he has been elected and has served as mayor of Pampanga for 3 consecutive terms, that being 2007 to 2010, 2010 to 2013, and 2013 to 2016. However, Morales insists that his second term as mayor of the municipality of Mabalacat was interrupted by the conversion of the municipality into a component city. Thus, Morales claims that Mabalacat City is an entirely different political unit from the municipality of Mabalacat, having an increased territory, income, and population. However, it was held in the previous case, Latasa versus Comelec, that the conversion of a municipality into a city does not constitute an interruption of the incumbent's official continuity of service. Thus, he had fully served the 3 consecutive terms. This thus the his disqualification was proper. And what now happens as to the votes cast in his favor? So um, the Supreme Court held here that as to the vacancy due to a cancellation of a COC, a person whose COC has been denied due course and or cancelled under Section 78 is deemed to have not been a candidate at all because his COC is considered void ab initio and thus cannot give rise to a valid candidacy and necessarily to valid votes. In case of vacancies caused by those with void ab initio COCs, the person legally entitled to the vacant position would be the candidate who's garnered the next highest number of votes among those eligible. In this case, it is Garbo, who is legally entitled to the position of mayor, having had the highest number of votes among the eligible candidates. Thus, the Comelec correctly proclaimed Garbo as the mayor of Mabalacat City. Abundo Jr. versus Comelec. The facts of the case are as follows. For four successive regular elections, namely the 2001, 2004, 2007, and 2010 national and local elections, Abundo vied for the position of municipal mayor of Viga Catanduanes. In both the 2001 and 2007 runs, he emerged and was proclaimed as the winning mayoralty candidate and accordingly served the corresponding terms as mayor. In the 2004 election, however, the Viga Municipal Board of Canvassers initially proclaimed as winner one Jose Torres, who in due time performed the functions of the office of mayor. Abundo protested Torres's election and proclamation, and Abundo was eventually declared the winner of the 2004 mayoralty electoral contest, paving the way for his assumption of office starting May 9, 2006, until the end of the 2004 to 2007 term. On June 30, 2007, or for a period of a little over 1 year and 1 month. Then came the May 10, 2010 elections where Abundo and Torres again opposed each other. When Abundo filed his certificate of candidacy for the mayoralty seat relative to this electoral contest, Torres sought Abundo's disqualification, contending that Abundo had served 3 consecutive terms as mayor of Viga. The RTC declared Abundo ineligible to run in the 2010 elections for violating the 3-term limit rule, and Comelec and Bank affirmed the ruling. Whether or not Abundo is an eligible candidate for the 2010 elections. The answer is yes. The court finds that Abundo's case is meritorious and declares that the 2-year period during which his opponent Torres was serving as mayor should be considered as an interruption, which effectively removed Abundo's case from the ambit of the 3-term limit rule. As held in a long line of cases, when a permanent vacancy occurs in an elective position and the official merely assumed the position pursuant to the rules on succession under the local government code, then his service for the unexpired portion of the term of the replaced official cannot be treated as one full term as contemplated under the subject constitutional and statutory provision that service cannot be counted in application of any term limit. If the official runs again for the same position he held prior to his assumption of the higher office, then his succession to said position is by operation of law and is considered an involuntary severance or interruption. There can be no quibbling that during the term 2004 to 2007 and with the enforcement of the decision of the election protest in his favor, Abundo assumed mayoralty post only on May 9, 2006 and served the term until June 30, 2007 for a period of only 1 year and 1 month. Consequently, unlike Mayor Ong in Ong and Mayor Morales in Rivera, it cannot be said that Mayor Abundo was able to serve fully the entire 2004 to 2007 term which he was otherwise entitled. Wherefore, the decision of the RTC is reversed and set aside, and Petitioner Abelardo Abundo Sr. is declared eligible for the position of Mayor of Viga Catanduanes, to which he was duly elected in the May 2010 elections, and is accordingly ordered immediately reinstated to said position. Agustin versus Comelec. The facts of the case are as follows. In 1997, Petitioner Agustin was naturalized as a citizen of the United States of America. In 2012, he filed his certificate of candidacy for the position of Mayor of the Municipality of Marcos, Ilocos Norte, to be contested in the May 2013 local elections. As the official candidate of the Nacionalista Party, he declared in his COC that he was eligible for the office he was seeking to be elected to, that he was a natural-born Filipino citizen, and that he had been a resident of the municipality of Marcos for 25 years. Respondent Salvador Pilos, a rival mayoralty candidate, filed in the Comelec a petition to deny due course and to cancel the COC of Agustin, alleging that the petitioner had made a material misrepresentation in his COC by stating that he had been a resident of the municipality of Marcos for 25 years, despite having been registered as a voter therein only on May 31, 2012. Pilos alleged that the certification issued by the Bureau of Immigration reflected that the petitioner had voluntarily declared in his travel documents that he was a citizen of the USA, that when he traveled to Hawaii on October 6, 2012, he still used his US passport despite his renunciation of his US citizenship on October 2, 2012, and after filing his COC on October 5, 2012. Pilos contends that the Agustin's declaration of his eligibility in his COC constituted material misrepresentation because of his failure to meet the citizenship and residency requirements. On April 23, 2013, the Comelec en banc issued its assailed resolution canceling and denying due course to petitioner's COC. On election day, however, the name of Agustin remained in the ballot. He was later on proclaimed as the duly elected mayor of Marcos, Ilocos Norte for having garnered the most number of votes. The petitioner then instituted his case alleging grave abuse of discretion by the Comelec en banc. So in this case, there are two issues to be tackled. The first is whether or not Agustin is eligible as a candidate for the position of mayor, and the answer is no, and whether or not the runner-up Pilos should instead be proclaimed as the mayor, and the answer there is yes. So as to the first issue on the eligibility of Agustin, he is not eligible because he filed a valid COC, but the use of his US passport after his renunciation of foreign citizenship rendered him disqualified from continuing as a mayoralty candidate. It is not disputed that on October 6, 2012, after having renounced his US citizenship and having already filed his COC, he traveled abroad using his US passport, thereby representing himself as a citizen of the USA. He continued using his US passport in his subsequent travels abroad despite having already been issued a Philippine passport. He thereby effectively repudiated his oath of renunciation on October 6, the first time he used his US passport after renouncing his US citizenship on October 2. Consequently, he should be considered an exclusively Filipino citizen only for the 4 days between October 2 and October 6. The petitioner's continued exercise of his right as a citizen of the USA through the use of his US passport after the renunciation of his US citizenship reverted him to his earlier status as a dual citizen. Such reversion disqualified him from being elected to public office in the Philippines pursuant to Section 40, Paragraph D of the Local Government Code. Thus, we go to the second issue on the valid proclamation of Pilos. So yes, Pilos was validly proclaimed because any candidate who has been declared by final judgment to be disqualified shall not be voted for, and the votes cast for him shall not be counted. The effect consequently was to render the votes cast in Agustin's favor as stray votes, resulting in Pilos being proclaimed as the winning candidate. Wherefore, the court dismisses the petition for certiorari and declares Salvador Pilos as the duly elected mayor of the municipality of Marcos in the May 2013 elections. Okay, before I hand you over to my groupmates, let's just make a quick recap on the 5 cases we have discussed. So, the first case, Gamboa versus Aguirre, the key doctrine here is when a vice governor temporarily assumes the office of the governor, he cannot exercise the powers unique to the office of the vice governor during the period that he is serving as the acting governor. In the second case, Navarro versus Court of Appeals, the doctrine here is when a person is appointed to fill a vacancy in the Sanggunian, such appointee shall come from the same political party as that of the Sanggunian member who caused the vacancy. In the third case, Morales versus Comelec, in case of vacancies caused by the cancellation of COCs, the person legally entitled to the vacant position would be the candidate who garnered the next highest number of votes among those eligible. In the fourth case, Abundo versus Comelec, when a permanent vacancy occurs in an elective position and the official merely assumed the position pursuant to the rules on succession under the LGC, then his service for the unexpired portion of the term of the replaced official cannot be treated as one full term. And lastly, Agustin versus Comelec, a candidate disqualified by final judgment before an election cannot be voted for, and the votes cast for him shall not be counted. So that's it. Thank you for listening, and I hand you over to my groupmate, Miss Paez. Thank you, everyone.
Thank you, Mr. Navarro. Good morning, classmates. I'm Pamela Paez and I will be discussing the cases on local legislation and disciplinary power. So in La Carlota City, Negros Occidental versus Attorney Rojo, the case involves the appointment of Attorney Rex Rojo as Sangguniang Panglungsod Secretary, contested by La Carlota City officials, challenging the validity of Rojo's resignation and the quorum during its acceptance, with the Court of Appeals affirming the Civil Service Commission's approval of Rojo's appointment. So the background of the cases are as follows. Attorney Rex Rojo was appointed by the former Vice Mayor Rex Halandon of La Carlota City, Negros Occidental as Sangguniang Panglungsod Secretary with a permanent status. The Civil Service Commission Negros Occidental Field Office or CSCFO Negros Occidental found infirmities in the appointment documents, such as the chairman of the Personnel Selection Board and the Human Resource Management Officer did not sign the certifications, the latter relative to the completeness of the documents as well as to the publication requirement. So Halandon brought the matter to the CSC Regional Office Number 6 in Iloilo City by way of an appeal. He averred that the Human Resource Management Officer of La Carlota City refused to affix his signature on Rojo's appointment documents, but nonetheless transmitted them to the CSCFO. However, such transmittal should be construed that the appointment was complete and regular, and that it complied with the pertinent requirements of a valid appointment. La Carlota City officials contested the recall, citing non-compliance and ineffective resignation. So the procedural history of this case are CSC Regional Office Number 6 reversed the recall, citing legal personality and compliance with election ban period. The Civil Service Commission dismissed the appeal, stating the appellants were improper parties. Court of Appeals upheld the Commission's decision, emphasizing Rojo's qualifications and substantial compliance with appointment requirements. The petitioners, they contended that the Rojo's resignation was ineffective due to quorum issues and the appointment violated the election ban. The respondent contended that Rojo's appointment met the qualifications and the vice mayor should be included in quorum calculation. So the issues in this case are whether the quorum was validly constituted during the acceptance of Rojo's resignation and whether Rojo's appointment violated the election ban from March 26 to May 9, 2004. So, as to the quorum, the court ruled yes. The court upheld Rojo's appointment, emphasizing compliance with the qualifications and appointment requirements under Section 469, Paragraph B, Article 1, Title 5 of the Local Government Code. The court applied Section 82D of RA 7160, deeming Rojo's resignation accepted upon presentation despite quorum challenges. In determining a quorum, Section 53 of the Local Government Code of 1991 provides that a majority of all the members of the Sanggunian who have been elected and qualified shall constitute a quorum. Along this line, it bears to emphasize that per Section 467, Paragraph A of the Local Government Code of 1991, the Sangguniang Panlalawigan is a composite body where the Vice Governor, as presiding officer, is composite member thereof. As a composite member in the Sangguniang Panlalawigan, he is therefore included in the determination of a quorum. Further, in the 2004 case of Zamora versus Governor Caballero, the court interpreted Section 53 of RA 7160 to mean that the entire membership must be taken into account in computing the quorum of the Sangguniang Panlalawigan, was decided under the 1987 Constitution and after the enactment of the Local Government Code of 1991. The court in Zamora clearly included the vice governor as presiding officer as part of the entire membership of the Sangguniang Panlalawigan, which must be taken into account in computing the quorum. In this case, a quorum of the Sangguniang Panglungsod should be computed based on the total composition of the Sangguniang Panglungsod. So the Sangguniang Panglungsod of La Carlota City, Negros Occidental is composed of the presiding officer, 10 regular members, and 2 ex-official members, or a total of 13 members. A majority of the 13 members of the Sangguniang Panlungsod, or at least 7 members, is needed to constitute a quorum to transact official business. Since 7 members, including the presiding officer, were present on the 17th of March 2004 regular session of the Sangguniang Panlungsod, clearly there was a quorum such that the irrevocable resignation of the respondent was validly accepted. Hence, the decision emphasized that the vice mayor should be included in the quorum calculation as per DILG Opinion Number 28, Series 2000. As to the violation of the election ban, the court ruled no. The court agrees with the finding of the Court of Appeals and the Civil Service Commission that since the respondent's appointment was validly issued on the 18th of March 2004, then the appointment did not violate the election ban period, which was from 26th of March to the 9th of May 2004. The appointment of respondent on March 18, 2004 was validly issued considering that 1. He was considered resigned as Sangguniang Panglungsod member effective March 17, 2004. Second, he was fully qualified for the position of the Sangguniang Secretary. And third, there was substantial compliance with appointment requirements. In this case, the Service Commission found that despite the lack of the signature and certification of the Human Resource Management Officer of La Carlota City on respondents' appointment papers, the respondents' appointments is deemed effective as of March 18, 2004, considering that there was substantial compliance with appointment requirements. Hence, the court dismissed the concerns about the election ban uh, violation, finding no evidence of a midnight appointment. The next case is Javier et al. Versus Cadiao et al. So, in this case, the case involves the validity of the reorganization of the standing committees of the Sangguniang Panlalawigan of Antique, challenged by members who argued that the required majority for urgent matters wasn't met, leading to their removal from committee positions. The RTC upheld the reorganization, stating that the vice governor's vote was not necessary for a majority in this context. So the background of the case are as follows. The Lakas ng Tao Christian Muslim Democrats or Lakas CMD bloc was initially considered the majority party. Included in the group were Tobias Javier, referred to as Javier, and Vincent Picho III, referred to as Picho, and collectively known as the petitioners. The party also comprised Vice Governor Cajao and SP member Benjamin Juanitas. So Picho assumed the role of a majority floor leader. Conversely, the Nationalist People's Coalition or NPC was acknowledged as the minority party consisting of 4 members, among whom is the present respondent, Alfonso Combong Jr. Due to political shifts, the National People's Coalition gained superiority in numbers. Combong resolution was proposed to reorganize committees, triggering a legal challenge by Lakas CMD members. So the RTC upheld the validity of the Combong resolution, stating legislative rules were not permanent. So it excluded the vice governor's vote in majority calculation for urgent matters. So in determining the validity of the passage of the Combong resolution, Section 67, Rule 18, IRP of SP should be applied. So it states that the presiding officer shall put the question saying as many as are in favor of, as the question may be, or raise your hand, and after the affirmative vote is counted, as many as are opposed also raise your hands. So unless otherwise provided by these rules, a majority of those voting, there being a quorum, shall decide the issue. An abstention shall not be counted as a vote. In determining the majority vote, only the number of those who voted shall be considered. Abstentions are excluded. So even if the most of the members present abstained, this will not affect the result, as the only thing to be determined is which of the affirmative and the negative vote has the bigger number. Only the number voting on each side and not the names of the members shall be indicated in the minutes. So they declared no grave or irreparable injury to Lakas CMD members. So the Lakas CMD argued that a two-thirds majority was needed for the Combong resolution and questioned the exclusion of the vice governor's vote. The respondents contended that the RTC lacked jurisdiction, the reorganization was legal, and no grave injury occurred. So the issue in this case is whether or not a vice governor who belongs more to the executive branch of the government should be excluded from the base number in determining what constitutes a majority. So the court ruled yes. The Supreme Court ruled that the vice governor, as the SP's presiding officer, should be counted for purposes of ascertaining the existence of a quorum, but not in the determination of the required number of votes necessary to uphold a matter before the SP. RA 7160 clearly states that the Sangguniang Panglungsod shall be composed of the city vice mayor as presiding officer, the regular sangguniang members, the president of the city chapter of the Liga ng mga Barangay, the president of the Panglungsod ng Federasyon ng mga Sangguniang Kabataan, and the secretary representatives as members. Also, the Black's Law Dictionary defines composed of as formed of and consisting of. So as with the presiding officer, the vice mayor can vote only to break a tie. In effect, the presiding officer votes when it matters the most, that is, only to break a deadlock in the votes. So clearly, the vice mayor as presiding officer is a member of the Sangguniang Panglusod, considering that he is mandated under Section 49 of RA 7160 to break a tie. To construe otherwise would create an anomalous and absurd situation where the presiding officer who votes to break a tie during a Sangguniang session is not considered a member of a Sanggunian. Further, the law cannot reasonably require that a vice governor be included in the determination of required number of votes necessary to resolve a matter every time the SP votes on an issue. It bears stressing though that while the vice governor does not enjoy full rights of participation in the floors of SP as the holder of the body's politics general mandate, the power to render conclusion to an issue when there is deadlock pertains to him or her. Here in this case, when the Combong resolution was deliberated upon, all 10 regular and 3 ex-officio members plus the presiding officer were present. 7 members voted for while 6 voted against the Combong resolution. There was no tie to break as the majority vote had already been obtained. Hence, Section 49 of the Local Government Code is explicit that the presiding officer shall vote only to break a tie. So, in the case of Conchita Carpio case, the background of the case are as follows. So, in July 2014, a complaint was filed accusing Judge Amar Erwin Binay Jr. and other officials of the city government of Makati of plunder and violating anti-corruption laws in connection with the Makati City Hall parking building project. The Ombudsman initiated investigations and on March 5, 2015, filed a complaint against Binay Jr. and others, including 6 administrative cases and 6 criminal cases. The charges pertain to irregularities in various phases of the project during Binay Jr.'s terms as city mayor. On March 10, 2015, a preventive suspension order was issued for 6 months without pay based on strong evidence of guilt and the potential influence of the accused in their positions. The Ombudsman directed the Department of Interior and Local Government or DILG to implement the order. A copy was sent to the office of the seat of mayor on March 11, 2015. So the Court of Appeals granted Binay Jr.'s TRO petition questioning the Ombudsman's preventive suspension order, and it also cited the continuation doctrine as a potential defense against administrative liability. So the implementation of TRO, the Court of Appeals resolution resulted in the implementation of the TRO, allowing Binay Jr. to retain his position temporarily. So the ombudsman position argued that the CA had no jurisdiction to issue a TRO against the ombudsman's disciplinary power. It also contested the propriety of subjecting the ombudsman to contempt proceedings, being an impeachable officer. So the issue in this case is whether the ombudsman has the authority to issue a preventive suspension order. So the court ruled yes, the ombudsman has authority to issue a preventive suspension order. Under Section 12, Article 11 of the 1987 Constitution, the office of the ombudsman is envisioned to be the protector of the people against the inept, abusive, and corrupt in the government, to function essentially as a complaints and action bureau. So this constitutional vision of a Philippine ombudsman practically intends to make the Ombudsman an authority to directly check and guard against the ills, abuses, and excesses of the bureaucracy. Further, Section 21 of RA 6770 states that officials are subject to disciplinary authority. The exceptions of it is that the office of the ombudsman rather shall have disciplinary authority over all elective and appointed officials of the government and its subdivisions, instrumentalities, and agencies including members of the cabinet, local government, government-owned or controlled corporations and their subsidiaries, except over officials who may be removed only by impeachment or over members of the Congress and the judiciary. The requisites for issuing a preventive suspension order are explicitly stated in Section 24 RA 6770. So the ombudsman or his deputy may preventively suspend any officer or employee under his authority pending an investigation if, in his judgment, the evidence of guilt is strong, and A, the charge against such officer or employee involves dishonesty, oppression, or grave misconduct or neglect in the performance of duty. B, the charges would warrant the removal from the service. Or C, the respondent's continued stay in office may prejudice the case filed against him. So the preventive suspension shall continue until the case is terminated by the office of the ombudsman, but not more than 6 months without pay, except when the delay in the disposition of the case by the office of the ombudsman is due to the fault, negligence, or petition of the respondent, in which case the period of such delay shall not be counted in computing the period of suspension herein provided. So the ombudsman's broad investigative and disciplinary powers include all acts of malfeasance, misfeasance, and nonfeasance of all public officials, including members of the cabinet and key executive officers during their tenure. To support these broad powers, the Constitution saw it fit to insulate the office of the Ombudsman from the pressures and influence of officialdom and partisan politics, and from fear of external reprisal by making it an independent office. Further, the court mentioned the case of Gonzales The third, a landmark case exploring the concept of the ombudsman's independence concerning the constitutional bodies. The court emphasized that the independence shared by the ombudsman and the constitutional commissions is characterized by being constitutionally created and enjoying a fiscal autonomy. The framers of the Constitution intended to insulate these bodies from political pressure to preserve their core functions. So the decisive ruling in Gonzales III affirmed that the independence of the ombudsman and similar bodies um, means freedom from control or supervision by the executive department. So in that case, the court also cited uh, previous cases to illustrate how the Constitution prevents presidential interference with the independent constitutional commissions. So, in declaring Section 8, Paragraph 2 of RA 6770 partially unconstitutional, Gonzales III asserted that the Deputy Ombudsman cannot be subjected to the disciplinary authority of the President. However, the validity of the same provision regarding the office of the Special Prosecutor was upheld as it is not considered constitutionally within the Ombudsman's office and that doesn't enjoy the same level of independence. So, the concept of ombudsman independence involves three key aspects such as constitutional creation, fiscal autonomy, and the installation of executive supervision. These elements aim to protect the ombudsman from political harassment, ensuring its effectiveness. However, the court clarified that ombudsman independence cannot be used to exempt the office from judicial power constitutionally vested in the courts. The judiciary's role is crucial in maintaining impartially and applying justice equally, contrary to the Ombudsman's claim of exemption from judicial power, particularly regarding the provisional writs of injunction against preventive suspension orders. Hence, the Ombudsman possesses disciplinary power when supported by strong evidence and to prevent prejudice to the investigation. So next is the case of the Tor versus Honorable Conchita Carpio Morales et al. So the background of the case are as follows. Mayor Dator hired his sister as municipal administrator without the necessary appointment process. Allegations included nepotism, lack of qualifications, and failure to follow the local government code. Dator argued that the position was confidential, non-career, and the appointment was for payroll purposes only. The Ombudsman found the Dator administratively liable for simple misconduct leading to a dispute on the imposed penalty. So the Ombudsman found the Dator administratively liable for simple misconduct, imposing a 6-month suspension. So the Dator appealed questioning the penalty and invoking the Aguinaldo Doctrine or the Condonation Doctrine, and the CA dismissed the Dator's petition for injunction on procedural grounds. So the Dator raised issues of condonation and conflicting penalties in his petition for review on certiorari to the Supreme Court. So the Dator contends that Aguinaldo Doctrine applies and imposed penalty is inconsistent. However, on the other hand, the Ombudsman argues that the suspension is justified for the Dator's irregular appointment practices. So the issue in this case is whether or not the Aguinaldo Doctrine, otherwise known as the Condonation Doctrine, still applies to this case. So the court held no, the condonation principle is deemed inapplicable to the Dator, contrary to his assertion. The case of the Office of the Ombudsman versus Mayor Julius Cesar Vergara clarified that the doctrine of condonation has no legal authority in the Philippines. The court's decision in Conchita Carpio Morales versus CA and Jejomar Binay Jr. emphasized that the condonation doctrine lacks legal basis and is inconsistent with the constitutional mandate of public accountability. An elective local official's administrative liability for the misconduct during a prior term cannot be absolved merely because they were elected to a subsequent term. The court refuted the idea that the election serves as a mode of condoning administrative offenses. It highlighted that neither the Constitution nor statutes support the notion that an official elected for a different term is absolved of administrative liability for offenses committed in a prior term. The court rejected the argument that the condonation is implied by the re-election of a local official, stating that no legal provision supports such a theory. It emphasized the lack of presumption in any statute or procedural rule that the electorate has full knowledge of a public official's misdeeds when casting their votes. The court concluded that there is no legal basis for the condonation doctrine in the Philippines. However, it clarified that abandonment of the condonation doctrine is prospective, meaning it applies to the cases arising after the court's ruling in Conchita Carpio Morales versus C. and Jajamar Binay Jr. Therefore, in cases that transpired before this ruling, the condonation doctrine remains applicable. So here, the case involved application of Rule 43 for appeals from ombudsman decisions, emphasizing the need for a uniform appellate. So, for procedure for quasi-judicial agencies. So the petition underscored the potential injustice of an immediate and lengthy suspension without a clarity on the penalty's duration and the unresolved motion for clarification. The court acknowledged the tension between procedural rules and the equitable consideration of providing swift and fair resolution, especially in cases involving elected officials. The Ombudsman's recommendation of a 6-month suspension without pay for simple misconduct was based on the irregularities in the TOR's appointment process and failure to follow legal procedures. The Ombudsman's rationale highlighted the significance of transparency and adherence to legal standards in the exercise of the disciplinary power against public officials. Hence, as the legal proceedings against the TOR were initiated on May 2, 2016, which is subsequent to the landmark decision of this court in the pivotal case involving Conchita Carpe Morales versus CA and Jejomar Erwin Binay Jr., it is evident that the condonation principle does not apply to him. So before I pass this to Mr. Panopio, let's review the cases previously discussed. So the doctrines in these cases are in La Carlota versus Rojo, the irrevocable resignations by the Sangguniang members shall be deemed accepted upon their presentation before an open session and its application to the determination of quorum in local legislative bodies. In Javier versus Candiao, the vice governor as the presiding officer of the Sangguniang Panlalawigan is considered part of the SP for determining quorum but excluded in the majority vote calculation unless a tie needs breaking. So in Carpio Morales versus CA, the Ombudsman as a constitutional body has the disciplinary power to preventively suspend public officials facing administrative charges when supported by strong evidence and when their continued stay in the office may prejudice the investigation. In the TOR versus Carpio Morales, the doctrine in this case is that in the exercise of the disciplinary power, government officials must adhere to the proper appointment processes and qualifications, emphasizing the need for transparency and compliance legal procedure. That's all for the cases involving local legislation and disciplinary power. The next reporter is Mr. Panopio. Thank you.
Thank you, Ms. Paez. Now we move on to the topic of recall. To better understand this concept, let's take the case of Other Mayo versus Comelec. So the facts of this case is that the respondent Talaga Jr. was elected mayor of Lucena in May 1992. Again, he was re-elected in 1995 to 1998 and fully served his term of office. However, in the May 1998 elections, it would be his third term as mayor, but he lost to Bernard Tagarao. Continuously, in the recall election of May 2000, he again won and served the unexpired term of Tagarao until June 2001. For the May 2001 elections, Talaga filed his certificate of candidacy once again for the office of mayor. He and petitioner Raymond Adormeo were the only candidates. Petitioner filed a motion to cancel certificate of candidacy and or disqualification of Talaga Jr. on the ground that the latter was elected and had served as city mayor for 3 consecutive terms. So the petitioner contended that Talaga's candidacy as mayor constituted a violation of Section 8, Article 10 of the 1987 Constitution. Respondent stated that he was not elected city mayor for 3 consecutive terms, but only for 2 consecutive terms. He pointed to his defeat in the 1998 election by Tagarao. Because of his defeat, the consecutiveness of his years as mayor was interrupted, and thus his mayorship was not for 3 consecutive terms of 3 years each. So the Comelec initially disqualified Talaga, but he filed a motion for reconsideration which was granted by the Comelec. Now, Adarmeo then filed a petition for certiorari with the Supreme Court. So the main issue in this case, which is relevant to our topic, is whether or not the private respondent, as provided by the Constitution, had already served 3 consecutive terms in that office and is disqualified to run for mayor. So the Supreme Court held that the private respondent has not yet served the 3 consecutive terms. The term limit for elective local officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Consequently, it is not enough that an individual has served 3 consecutive terms in an elective local office. He must also have been elected to the same position for the same number of times before the disqualification can apply. The Supreme Court stated that the 2 conditions for the application of the disqualification must concur. First is that the official concerned has been elected for 3 consecutive terms in the same local government post, and the second is that he has fully served 3 consecutive terms. So the continuity of Talaga's mayorship was disrupted by his defeat in the 1998 elections. The time between his second term and the recall election is sufficient interruption. Thus, there was no 3 consecutive terms as contemplated in the disqualifications in the LGC. Neither can the respondent's victory in the recall election be deemed a violation of Section 8, Article 10 of the Constitution as voluntary renunciation, for clearly it was not. Talaga vacated his post a few months before the next mayoral elections, not by voluntary renunciation, but in compliance with the legal process of the writ of execution issued by the Comelec to that effect. Such involuntary severance from office is an interruption of continuity of service, and thus the petitioner did not fully serve the 1995 to 1998 mayoral term. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which he was elected. The clear intent of the framers of the Constitution to bar any attempt to circumvent the 3-term limit by a voluntary renunciation of office and at the same time respect the people's choice and grant their elected official full service of a term is evident in this provision. Hence, private respondent was not disqualified to run for mayor in the May 14, 2001 elections. Continuing, let us discuss the case of Socrates versus Comelec. The facts of the case are as follows. On July 2, 2002, when 312 out of 528 incumbent barangay officials in Puerto Princesa convened a preparatory recall assembly and passed a resolution expressing loss of confidence in Mayor Victorino Dennis Socrates and calling for his recall. This assembly, which appointed Mark David Hagedorn as interim chair, requested Comelec to organize the recall election within 30 days. Subsequently, Socrates filed a petition with Comelec to nullify the recall resolution. However, the Comelec dismissed Socrates' petition, upheld the recall resolution, and scheduled the recall election. In preparation for this, Comelec issued a resolution outlining the campaign period and related activities. During this period, Edward Hagedorn filed his candidacy for mayor in the recall election. The eligibility of Hagedorn became a contentious issue, with several petitions filed with Comelec challenging his candidacy on the grounds that he had already served his 3 consecutive terms as mayor, thus disqualifying him from running for a 4th consecutive term. So these petitions were consolidated by the Comelec, which later dismissed them and declared Hagedorn qualified to run in the recall election, subsequently rescheduling the election. In response, Socrates sought to nullify Comelec's resolution that gave due course to the recall resolution and scheduled the recall election. He alleged that the Comelec gravely abused its discretion in upholding the recall resolution, citing several legal infirmities in the convening of the PRA and the issuance of the recall resolution, including insufficient notification of PRA members, deficient proof of service of notice, and violations of constitutional rights to information. So the issue in this case is that whether or not the Comelec committed grave abuse of discretion in upholding the recall resolution and in qualifying Hagedorn to run in the recall election. So the Supreme Court ruled that the Commission on Elections did not commit grave abuse of discretion in upholding the recall resolution and in qualifying Hagedorn to run in the recall election. The court's decision was based on the interpretation of the constitutional and statutory provisions on the 3-term limit rule for elective local officials. The court noted that the Constitution in Section 8, Article 10, and the Local Government Code in Section 43B restrict elective or local officials to 3 consecutive terms with the clear intent that only consecutive terms count towards the limit. It emphasized that voluntary renunciation of office does not interrupt the continuity of service, but involuntary severance does. Applying these principles to Hagedorn's case, the court found that his nearly 15-month absence from office, although not a full term of 3 years, constituted an interruption in the continuity of his service. This interruption meant that Hagedorn's candidacy in the recall election was not for a 4th consecutive term, since there was a break in service, making him eligible to run. The court distinguished the case from Lonzanida versus Comelec, underscoring that an elective local official out of the office interrupts the continuity of service, preventing a recall term from being a seamless continuation of previous terms. The court also referred to its ruling in Adarmeo, reiterating that an interruption in service, even if short of a full term, breaks the continuity of service for an elective local official. Ultimately, the court concluded that Hagedorn's recall term did not constitute a consecutive 4th term, as his service was involuntarily interrupted. The court underscored the importance of strictly construing term limits to respect the sovereign will of the people to choose their leaders. The rule affirmed that Hagedorn's recall term, starting from the date he assumed office after winning the recall election, was a new term and not a continuation of his previous terms. Continuing, let us now discuss the case of Angubong versus Comelec. So the facts of the case are as follows. The petitioner won as the duly elected mayor of the municipality of Tumawini, Isabela in the local elections of 1995. Respondent De Alban was also a candidate in the said elections. The respondent filed a petition for recall against the petitioner, and the Deputy Executive Director for Operation Hoson submitted to the Comelec and Bank a memorandum recommending approval of the petition for recall filed by private respondent and its signing by other qualified voters in order to garner at least 25% of the total number of registered voters as required by the local government code. The Comelec and Bank issued the herein assailed resolution 96-2951. So the petitioner now attacks the affirmation resolution as being unconstitutional and therefore invalid on 2 main grounds. First is that the resolution approved the petition for recall, albeit Same was signed by just one person in violation of the statutory 25% minimum requirement as to the number of signatures supporting any petition for recall. And second, that the resolution scheduled the recall election within 1 year from May 12, 1997 barangay election. So the issue in this case is that whether or not the petition for recall may proceed even though the statutory minimum requirement was not met. And the court said no. The Supreme Court held that the petition for recall against Mayor Angobong cannot proceed because the statutory minimum requirement of 25% of the total number of registered voter signatures was not met. The Supreme Court, in its decision, emphasized the local government code, which states that a recall petition can only be validly initiated with the support of at least 25% of the total number of registered voters in the concerned local government unit. The court found that the petition for recall filed by Maria Aurora de Alban was signed only by herself, not meeting the mandatory 25% threshold. This procedure, as the court pointed out, is indubitably violative of the clear and categorical provisions of the law. The court further elaborated that the rationale behind this requirement is to ensure that recall, as a powerful tool of direct democracy, is exercised responsibly and represents a substantial collective sentiment rather than the agenda of a small group or an individual. Consequently, the court declared the Comelec resolution, which had approved the insufficiently supported petition for recall, null and void. Let us now proceed in an election topic case. So in this case, Brillantes versus Yorak, the facts of the case are as follows. In December 1989, following a coup d'etat attempt in the Philippines, President Corazon Aquino established a fact-finding commission to be chaired by Hilario Davide. Davide's new role necessitated his resignation from his position as chairman of the Comelec. Subsequently, Heidi Yorak, who was then an associate commissioner at Comelec, was appointed by the President Aquino as acting commissioner of Comelec. This appointment was challenged by Sixto Brillantes Jr., who argued that it contravened the constitutional mandate for the independence of the Commission on Elections. He cited Article 9 of the Constitution, which states that no member of the Comelec should be appointed or designated in a temporary or acting capacity. The petitioner further condemns that the choice of the acting chairman of the Commission on Elections is an internal matter that should be resolved by the member themselves, and that the intrusion of the Philippine president violates their independence. He cites the practice in this court where the senior associate justice serves as acting chief justice in the absence of the chief justice. No designation from the president of the Philippines is necessary. So the main issue of this case, which is relevant to our topic, is that whether or not the designation made by the president violates the constitutional independence of the Comelec. And the Supreme Court held that yes, Yorak's designation as acting chairman is unconstitutional. The Supreme Court ruled, although essentially executive in nature, they are not under the control of the President of the Philippines in the discharge of their respective functions. Each of these commissions conducts its own proceedings under the applicable laws and its own rules and in the exercise of its own discretion. The designation made by the President has dubious justification as it was merely grounded on the quote, administrative expediency to present the functions of the Comelec. In the choice of the acting chairman, the members of the Commission on Elections would most likely have been guided by the seniority rule as they themselves would have appreciated it. In any event, that choice and the basis thereof were for them and not the president to make. To emphasize the importance of the Comelec's constitutionality guaranteed independence. The court said that the choice of a temporary chairman is an internal matter which comes under the discretion of the commission, a body, and that such discretion cannot be exercised for the commission by anybody else. But even though the president's appointment of Yorak as acting president is void, the members of Comelec can choose to reinstate Yorak as their acting chairman. What is the member should elect their acting chairman pursuant to the principle that constitutional commissions are guaranteed by the Constitution as an independent bodies. Okay, so let's have a quick review on what we have just discussed. First, on the case of Mayo versus Comelec. So this case, we discussed that this case reinforces the interpretation of consecutive terms within the meaning of the three-term limit for elective local officials in the Philippines. It clarifies that an involuntary interruption, such as a defeat in an election, resets the count of consecutive terms. This principle ensures that the term limit provision cannot be circumvented through recall elections and upholds the electorate's sovereign will. And in the case of Socrates versus Comelec, um, uh, in this case, in qualifying Hagedorn to run in the recall election, the court had to interpret the term limit provisions in the context of a special election, which a recall election essentially is. So the doctrine clarified that the prohibition on serving more than 3 consecutive terms should not mechanically bar an individual from running in a recall election, which is by nature an extraordinary mechanism for direct democracy. And the court recognized that a recall election is distinct from regular or scheduled elections and serve a different purpose. It is a tool for the electorate to directly express their satisfaction or dissatisfaction with an elected official. And by allowing Hagedorn to run in the recall election, the court's decision emphasized that term limits should not unduly restrict the democratic process in special circumstances like recall elections. Okay, so in the case of Angubong versus Comelec, um, this case established or reinforced the doctrine that recall petitions in the Philippines must be initiated by a significant portion of the electorate, specifically at least 25% of the registered voters. So this ruling underscores the collective nature of the recall process as a democratic remedy and guards against its misuse by an individual or minority interests. The decision highlights the importance of strict adherence to statutory requirements in the initiation of recall elections, ensuring that such a process truly reflects a substantial and collective expression of the electorate's will. And lastly, for the case of Brillantes versus Yorak, so the Supreme Court's ruling reinforced the principle that appointments within independent constitutional bodies such as the Comelec must be free from external influences, particularly from the executive branch of the government. So this doctrine affirms that the constitutional mandate for the independence of bodies like the Comelec is not merely a guiding principle, but a binding rule that must be adhered to in practice. It underscores that any appointments or successions within such bodies should be carried out internally, respecting the autonomy and independence envisioned by the Philippine Constitution. So that's it for our report. Thank you very much for listening and have a great weekend.